Tom Greatbeck.
I rise to speak in support of new clause 4, which is in my name. Unlike other members here present in the chamber today, I wasn't up until recently over familiar with this bill. I didn't serve on the bill committee, but the Minister may just recall a couple or 2 or 3 months ago I raised an issue with her at oral questions in relation to issues around warranties and additional warranties sold by retailers arising from a specific constituency case, but also, frankly, from a number of constituents who've been in touch with similar and related concerns and issues over the last 3 or 4 years. And the Minister, in her response to me, drew my attention to this bill, which was currently in its committee stage, and suggested that I should look to the bill for some comfort. So I did. I looked at the bill. I also read the committee proceedings from the relevant day when members of the committee considered issues around warranties. I see my honourable friend from East Lothian is in her place, and she raised some of these issues. I recall from my reading of those discussions around again around electronic goods, and she made the point of her experience, which I think she said she thought that the system may have got, or situation may well have got better since then. And the reason for my amendment is from an experience which demonstrates that actually in all cases that certainly isn't the case. Now, in the committee proceedings, and my honourable friend from the front bench from Walthamstow has already referred to the implementation group, and the implementation group does seem to be almost the catch-all for everything that is going to happen at some point unspecified in the future. But given that, as my understanding is, that the implementation group is there to be able to ensure that rights that are legislated are translated into something meaningful for consumers, I think it's entirely right and appropriate that in this amendment we seek to ensure that the implementation group, from a specific point after royal assent of this bill, comes forward with some guidance on a couple of specific issues which I want to just refer to briefly this afternoon. In relation to warranties, and guarantees, what I have found out from constituents is that very often people are being told what they're being told they're being sold and what they've actually been sold turn out to be very different things, and particularly in relation to additional or supplementary guarantees and warranties. And then often it turns out to be the case that they are sold these by the retailer, and the retailer makes the case to the individual that this is going to enhance their protection, their consumer protection, their enjoyment of the product, and give them some safeguard, when it turns out in reality that there's nothing more in the warranty than that which they're already legally entitled to, or is included in the manufacturer's own warranty. I will indeed.
Thank you. Does my honourable friend agree with me? It's not just that the warranties are sometimes missold, but companies such as Bright House and the rent-to-own market actually make it compulsory for new customers to take out a warranty, when indeed they may already have their own household insurance on those goods.
I think my honourable friend makes a very important point about that specific part of this market, and it's a point well made. It's also the case, I'm aware of from talking to others and other constituents, that there is almost an expectation upon the people working in other retailers, where there may not be it may not be obligatory for the consumers to have these warranties, but they are certainly expected to seek to try to sell these warranties, and in some cases even on the basis of commission to do so. And that leads to the concern that I have from this specific case, where what was written in the document that was signed was clear, but the way in which it was described and explained to the consumer certainly wasn't, and was very, very different. In this particular case, my constituents bought a television set from a high street electrical store, and had been told that the additional warranty that he was taking out on top of the manufacturer's warranty would entitle him to a new set if anything went wrong within the period, within a 5-year period. His television set did indeed break down during that period, but he found that in the small print he was entitled to repair or replacement, which was exactly the same as the manufacturer's guarantee, meaning he had paid a significant amount of money for him every month for something which was effectively worthless on the basis of what he had been told in the store. I fundamentally believe that retailers have a duty to consumers not to sell them products that they know to be worth this. And in the case of a warranty, that simply duplicating existing rights would appear to be the case. And because these warranties very often apply to what can be significantly expensive electronic goods, you can see how the consumer could very easily be persuaded to pay for an expensive warranty scheme which delivers them no extra benefit, and which often the retailer is probably very well aware delivers the consumer no additional benefit. And I think that's an area where the implementation group should certainly be undertaking some work, because I know that there's some clauses, clause 30 in this bill in relation to warranties, but it doesn't seem to cover this point. And in this particular case I'm referring to, I took up this issue both with the company and with my local trading standards office, who were very sympathetic, the trading standards office, but the long and short of it is that the practices that I've described are entirely legal, and there was nothing they could do other than advise people to be more aware next time, which isn't much comfort for someone who spent a significant amount of money on a product which hasn't then met his expectations or the protection he thought he was entitled to. Now, I understand this isn't a new problem. It's something which has been raised a number of times in committee, but also previously in this House. But I do think it's something which the implementation group should be charged with ensuring happens, and this amendment presents us with an opportunity to do that. The second issue covered in my amendment is around the management of deposits, and I raised this issue and tabled this part of the amendment after a local small business approached me regarding an account held with a telecommunications firm, in this case TalkTalk. As many members will be aware from their own constituents, telecommunications contracts for small businesses often require quite sizable deposits, and my constituent was asked to provide a bond of some £900. Now, the size of these deposits has been the subject of interest from the regulator, but I would draw the House's attention to the outcome of a dispute between Apple Telecom Europe Limited and BT around the level of security deposit required for services, where Ofcom stated they were unwilling to determine on what might be an appropriate deposit. In that light, it's clear the regulator isn't currently prepared to step into this space, but the size of some of the deposits places a clear responsibility on policymakers, I believe, to ensure the rights of that consumer and that service user are protected. After terminating their contract, the local business that approached me found that two issues arose. First was that TalkTalk were in no hurry to return the deposit being held. And the second was that when they did return the deposit, it was without any interest. And on the first point, TalkTalk made it clear they would hold on to the bond beyond the end of the 3-year agreed contract. Their intention effectively was to hold on to the bond, the deposit, until my constituent ceased to be a customer, and at which point it was on the onus of my constituent to write and request a return of that money. Now, my sense is the responsibility in this scenario is round the wrong way and places all of the obligation on the consumer and all of the potential benefit of not meeting that obligation on the retailer. Now, because the retailer was not required to return the bond in a timely fashion, it's also clear my constituent will be missing out on substantial interest payments on that £900 bond. And given that a number of these contracts can be for significant lengths of time, or may well be renewed over time, that could be over a period of time considerable amounts of money, particularly for small businesses. It's far from a trivial amount of money. So my amendment addresses both of these concerns by requiring the implementation group to report both on the length of time for which a retailer can retain a bond after the contract has been terminated, and on the payment of interest on this money. It doesn't seem to me it would be unduly burdensome for the company to be required to place bonds in a separate account, the interest on which is returned to the consumer at the end of the contracted term. On this second point, I'm sure the Minister is aware there are significant precedents in which interest is paid on money held. For example, solicitors are required to place monies held on trust for a client in a separate interest-bearing account, and that's made clear in the Professional Code of Ethics and the Solicitors Regulation Authority's handbook. Equivalent provisions cover other professions where the business is in the position of holding money on trust, for example, an accountant who holds funds for a client to settle a forthcoming tax bill. But beyond these examples, it's clear there is substantial licence for abuse. Now, we have recently had in the energy market concerns around monies being retained from excessive direct debit payments, which one of the Minister's colleagues in another department described as being unacceptable and that something needed to be done about it. I think the same case can be made in relation to the concerns I'm outlining this afternoon. So I'm conscious that the guidance and regulation arising from the work of the implementation group won't be applied retrospectively, and so wouldn't have an impact, direct benefit for the two cases that I've outlined. But I think their experience has important lessons to bear for all of us, and there are cases that could and probably will be repeated along the same lines in the future. And for that reason, I implore the Minister to look at this amendment sympathetically, to see that it is about enhancing the rights of consumers who are being and have been in many regards given poor advice or under the circumstance where they're not getting the service which I'm sure she and everybody else in this House would expect. I think the work of the implementation group, which is obviously has a degree of significance as the number of times the Minister has referred to it during committee stage, and I'm sure she'll refer to it in her remarks this afternoon, but it's also important that the implementation group gets on and delivers something from that, and I think that's what many people who have been following the progress of this bill will expect, and this is just one way in which I can see a very clear path for that implementation group to take some effect to benefit consumers and small businesses across the whole of the UK.
Minister.